Welcome all to the first webinar of the Center for K through 12 Captivity Studies, part of the Institute for Objective Policy Assessment, policytalk.org, that I head. Most school children are captives of an assigned traditional public school, and that captivity has many devastating consequences, some still unrecognized. And the objective of the center is a nationwide end to captivity, and a link to a brief explanation of captivity is in the chat, alongside a link to our guest's compelling article on today's topic. And my institute is partnering with the center to move us forward in K through 12 school system reform. We're very lucky to have Philip Hamburger as the featured member of our panel today. And Martha, the head of the Captivity Center, will be doing most of the early questioning. At about 2:40, we will open it up to the questions posted in the chat from our viewers, and then we'll go back to our questions if there aren't enough of those to fill up the hour. At 5 till, Professor Hamburger will sum up what we've learned today, and by way of introduction, most of you probably have corresponded with Mr. Hamburger. He teaches at the Columbia Law School. He's the CEO of the New Civil Liberties Alliance. He is the author of Education is Speech. And recently in the Wall Street Journal, he had an op-ed there, the Department of Education and the KKK. And without further ado, let me turn it over to Martha.
Thanks, John, for that great introduction for everyone, and welcome everyone. We're so grateful that you're here to listen to Philip and hear his arguments with respect to education as speech. It's a very important aspect of what we're trying to do at the Center for K-12 Captivity Studies, and we know a lot of you are doing similar things. We want an end to this captivity, this idea that in order to get a so-called free public education, you have to go to a government school. So again, we're very happy to have Philip Hamburger here to discuss his idea, because this is one way to get that done potentially. Philip, if I could please, I'd just like to start us off by asking, what is it that inspired you to address education as speech in the K-12 public school arena?
Is this loud enough?
Yes, it is.
Okay, good. So I could claim that it's my own captivity in schools. I changed school every year or two when I was a kid, and each was worse than the prior one. So maybe it was memories of that. But more seriously, I'm interested in freedom of speech. I'm also interested in freedom of religion. It struck me that the religious liberty arguments tended to be too narrow. It's not that they're unimportant, but they would liberate only some. And of course, education, once you think about it, it's mostly speech, almost entirely speech if you include that which is expressive conduct. And so why isn't there a speech claim here? And I don't mean, of course, a Pierce versus Society of Sisters type claim where there's some special concocted right that's just of parents. This is part of everyone's freedom of speech, just as applied to parents, as claimed by parents. So once that came into my head, the rest just followed. And it's a pretty straightforward argument. The parents have speech rights in educating their children because education is speech and shouldn't be displaced by government speech. So it was just that one idea led to this, I guess.
It's amazing.
And one more thing. What I guess I was pushed to this because of the Blaine amendments and studying anti-Catholicism. That also pushed me in this direction. Although I don't want to frame it that way because I've done enough work on that. I think it's important to get out of that conversation just to address the doctrinal issues directly.
And they were once. I have to speak for myself. I don't know how others thought this through, what your all of your thought processes were, but for me this was this light bulb moment when I read your argument, because of course education is speech, but I never had put those two things together. So that's either on me or maybe others have experienced the same thing. With such a strong argument behind using the First Amendment to challenge the current public education system. Why do you think it took so long for this argument to arise?
Oh, I don't know. A number of things come to mind. One, of course, is simply that tend to work as lawyers, we tend to work from doctrine, which comes out of cases. And Pierce versus Society of Sisters was litigated as a not on speech grounds because the parents weren't the litigants. It was the Society of Sisters joined by the Hill Military Academy. And so when an institutional, as it were, sellers of education, not the parents bringing the case, and that shaped how it's framed, that allows it to fit within the Lochner style cases of economic due process, which is a strength and weakness. It won the case, but substitute process is generally a weakish argument. But that meant that the parents' interests were largely left out of the case. So many people, I think, coming to this topic, whether in family law or in education, come to it working from out of the reasoning in Pierce, and that may have been misdirection. It's not that I'm against the case, it's very useful, but it leaves out some of the arguments necessarily just because of the configuration of the parties.
So maybe it's kind of the issue with everybody and with the way human thought goes, that if you focus really minutely on something, sometimes you fail to see the big picture. And that seems to be kind of what this is in a way. Have there been any education as speech cases brought in any states at all?
Not yet. But I'm certainly hoping we can bring some shortly, and that will be fun. Of course, one of the reasons we've been slow to do it is we want to scope out the problem very carefully. Just because I wrote an article on the subject doesn't mean we're going to win. And I like to win. So that means great caution. And there are a number of reasons for that. One, it's just one article, and there'll be other perspectives we have to take into account. For example, I failed to notice some Supreme Court dicta that cuts the other direction. I think we don't have to worry too much about it, but it's out there. But then, in addition, just the weight of practice over 150 years cuts against us, right?
Yes.
This may be doctrinally a strong argument, I hope, but that doesn't mean it's an easy argument, because many judges will say, well, schools have been around a long time. So that will be interesting.
Okay, since you've mentioned that, I'm going to cut to that question, and if you'll just hold on a minute, I want to talk to you about that question. The whole institutional longevity is what you're talking about. You mentioned that on page 449 of your article. That's a strong argument. A lot of people say, well, it's too big for us to crack. We have to leave it there because it's just too big. I would like to propose an alternative form of thinking and wonder if you would consider this, and that is what I'm calling the gradual fraying of an old system versus an abrupt cliff of canceling the old system. So the way the Center for K-12 Captivity Studies we believe that all you need to do, instead of canceling something, canceling the old system, all you have to do, instead of the presence of a patchwork of all different school choice programs in different states, all you have to do is take away one thing, and that is the tie of funding to government schools. So if you did that, it seems to me that what would happen then is that market options and other options would fill in, but it would be done gradually, that you wouldn't be canceling public schools, but you would be allowing for other things to happen.
Right.
With that kind of a scenario, do you think that that's the best way to approach this?
Oh, absolutely. Yes, I would entirely agree. The article does not argue against public schools.
Right.
On the contrary, it only argues along the lines you're suggesting, that the current funding for public schools is unconstitutional because it presses parents to submit their children to government speech instead of their own. So the objection is not, the goal is not to hold schools unconstitutional, public or private, but to just simply to hold the current funding unconstitutional. And that would leave public schools in the game. And that's probably a good idea. There's no reason why government can't supply public schools, but they have to persuade you in another way than simply economic force, right? So I would entirely agree. But the real danger is people grow up in their public schools. They seem very solid. It seems very American, which was the nativist emphasis, of course. And so how do you overcome those? I'd be interested in people's thoughts. How do you overcome those predispositions
Right.
in favor of public schools? That's a really tough one.
That to me is why, and this is not for me to debate with you or debate with anyone, but to me, it's the difference between the presence of an order by the court to do a specific thing and to add something as opposed to taking away something, and that is taking away the mandate that you have to attend a government school if you want that so-called free school. That's all.
Right. But just to illustrate sort of thing that worries me, many parents and judges are fond of public schools because they like the football teams. And so it's a very important thing to note that in some jurisdictions, private school students can play in their public school football teams. In other words, there'd be no threat to the football team if we succeed in such arguments. So that's the sort of thing that I mean, when you write an article, you don't think about this, but when you start thinking about litigation, you have to worry about all these little parameters that affect people's sentiments.
That's true. Okay, so you've also mentioned something, what you and I discussed offline, as well as what you discussed very compellingly in your article, is you talk about focusing your education of speech argument very narrowly, and it's focused on what you call state schooling. What do you think, what exactly is state schooling?
Right. So there I simply mean schools subject to the state. And I deliberately called it state schooling as opposed to public schooling, because public schooling just sounds a little too positive for my taste. It's state schooling. Now, you could say, well, what about local schools? Are those different? No, I think those are all part of the state school system. Each state has a system of public schools. Localities are authorized sometimes to fund them and certainly to run them, but they're state schools subject to state regulation and a state scheme of funding. So these are all what I call state schools. And maybe that wasn't clear enough. If I were to write this again, I would have specified what I meant by that, but one doesn't anticipate everything.
Well,
At least I can do it now. Thank you.
Well, thank you for that, because I wanted to make sure that what you really helped to clarify the center's argument about what it is that we're looking to change. And it really is the tie between funding and government schools. That's it.
Mind you, I mean, just out of personal experience, I've been to a lot of what we call private schools. They can be just as oppressive.
Yes.
So I'm for a broader liberation, but yes, I agree with you.
Okay, so that fact is then, to me, state schooling is not only the government schools, but the fact that funding is tied to them. So it's those two things together. It's like, 1A plus 1B equals 2 or
Right.
whatever.
This actually what you mentioned raises a point that I think would be important in litigation. Certainly we hope to make an important point from this, and which did not come up in the article. I generalize in the article about government provided educational speech, but maybe it'd be more accurate, at least in some states, talk about government funding for education, because in many states, the money doesn't go to conventional public schools. Also, let's go to charter schools, and some even goes to private schools.
Right.
And that's advantageous actually for the argument, because it makes clear that this is government funding, subject to a condition that you go to public schools. It's not, unless you fit into one of the alternatives, it's not the provision of public education, because if a public education is thought of as the service that's provided, then a judge might not entirely unreasonably say, oh no, wait a minute, It's not an offer of anything but public education. And so it's not really a funding issue. And I think that perspective would be wrong, but that's most clear in states where a range of different types of schools are funded. And it's certainly very important for us to recognize the real problem is the funding. It's not really a provision of public schools. And this becomes clear in your distinction between state and local schools. The state authorizes all the funding, but localities sometimes authorize a range of different educational settings. So it's important, which I failed to do in the article, to distinguish between the funding and the provision of the schools themselves. These may be separate things.
And yet I noticed in your article, and I don't remember what page it was on, where you were talking about the fact that it is state schooling means that it is majoritarian.
Yes.
So what happens is that majority culture shapes the education, regardless of what neighborhood you're in.
That's right. And so it seems to me this is very worrisome because if your rights to be protected, speech rights, it's a right independent of a majority to impose its views on you. By the same token, I'm sure there'd be a lot of concern that if funding is available for private schools of all sorts, some pretty odd ideas might be espoused in some schools, maybe even dangerous ideas, some people say. Now, I don't think that's as great a problem as folks think, but it is something one has to address in the course of litigation.
It brings to mind, and this is something I'd like the audience to discuss if they wish to, a lot of objection has come about with respect to critical theory that's been supposedly taught in some public schools, and then the ordering of the cancellation of that critical theory. So it's both sides are a control of speech in one way or the other.
Right.
Instead of allowing somebody who wants their children to learn critical theory go to an institution where they could, and somebody who does not want them to can go somewhere else.
Right. So there's not a left-right thing. People of all views, it seems to me, should be able to educate their children in their own perspective. And sometimes that will be a misbegotten perspective and sometimes not. And we won't know ahead of time which are which. But that's the way education used to be in America, whether in the 1770s or even as late as the 1820s. Parents had remarkable degree of control, and that's been undermined. Now, which is more dangerous, majoritarian control or minority freedom in educating one's kids? I would have thought we have ample evidence that majority control is rather worrisome. Certainly at least as bad as some minority control over one's own kids. But that's an empirical question.
It is. I'm going to move to our empirical question now because you mentioned it, and I think it's a good idea. You cited some empirical research that was done, Patrick Wolf's studies of private schools and their link to civics engagement and some of the other things that you mentioned. Is there other additional empirical evidence that you think might strengthen the legal argument that an organization such as ours or EdChoice or some of the others might help to put together? Some of the examples I think of are special education for children with special needs. There seems to me there's a lot we could do with that because I know there are lots of parents of children with special needs who are very concerned that their children are trapped in the particular school they're in. Mathematics taught only one way. Anything taught in a segregated or stratified school, which of course then implies to the students that they're second class. So there are all these different ways that if we could put some empirical evidence to it, it might help. And I was wondering if you had any.
I'm very sorry to say I do not, off the top of my head, have any suggestions about further empirical evidence. I should, but I don't. But it does seem to me that this ties into all the concerns of so many parents that their child, even if not disabled, needs some special attention. The reality is most children need a little bit of help along the way, and they can and it doesn't all fit into one neat government-created box, right? So if a child needs a little speech therapy, it really matters which speech therapist you get and in what institutional setting, or maybe outside of institutional setting, and that you can multiply that across 1,000 different sets of concerns a parent might have about their child. So parental choice seems to be profoundly important. And I think many parents get that simply because of their own experiences. But whether there's empirical data, I don't know. I'm very skeptical about the attempt to reduce human life to numerical quantification. Maybe a little time at the University of Chicago exacerbated my concerns along those lines.
Right.
So sorry, I don't have empirical data if that means numerical stuff.
Well, I guess I'm wondering whether other researchers might be able to collect things that would help the argument. That's what I'm looking
Yes,
to.
I'm sure somebody in the field could dig up a lot of evidence one way or another on that. It's just not what I have or know about.
Okay.
Thank you.
Sure. And I'm wondering, one of the things you mentioned leads right to another question we have on our list, and that is what John called the multidimensionality of school quality. You cannot judge school quality by the grades a student gets on a test. There are too many things that go into what is a quality education for a specific student. Would it help your legal argument to assert that multidimensionality of school quality? In other words, that the same school can be a really good fit for some, but not others.
Yeah, I think that makes a lot of sense. And that's both because of the variability of children and the variability of teachers and schools, right? And a single metric is not going to capture any of that, right? So yeah, I agree entirely.
Right. So you had mentioned various school choice options such as charter schools and private school choice and some others. In the recent past, several of those have been defended in court. And they have ultimately, in most cases, I believe, been defended successfully. But did the defense of those early narrowly targeted school choice expansions delay a look at your compelling argument? Did it take us in another direction? Or can it now help us? Can it help inform us?
I see no harm in having all these very, very different types of schools. And I think it's a different set of legal arguments, but that's fine. Actually, I do think it helps to have charter schools and others out there because it illustrates the degree to which the state is not providing schooling per se, it's providing funding. And by the way, other evidence of that is the degree to which we sometimes now have multi-district funding for district-controlled schools, right? So if you're in, one county and their funding is coming from several counties or from across the state, it's a reminder of the degree to which it's state pressure to go in through funding, even though it's a locally controlled school. So I actually think it's advantageous to have all these different choices out there. None of them, I think, are terribly satisfactory because charter schools, they're still, in a sense, government schools. They're just slightly more liberated versions of government schools. Or if they're private schools, they're highly controlled and manipulated. So that charter schools are not what I'm aiming at, but I think their existence helps the argument to some degree. So I have no complaint that other people have won other cases and other theories. That's great.
Okay, all right. Thank you for that. I guess it goes to, again, the presence versus the absence argument, which is presence of specific kinds of school choice, or is it just the absence of the tie of funding to any form of education? You give funding to what the parents think is best for their children.
Parental choice, I think, is very distinct from, I don't think you get parental choice in a charter school situation. It's a move in that direction. That's healthy and good. But it seems to me ultimately parents should be able to choose their speech as much as in any other sphere of life. Education shouldn't be a second-rate version. Educational speech should not be a second-rate version of speech.
Yes. Thank you for that. So let's look at that education as speech or First Amendment approach to providing parental freedom in education versus what you also mentioned in your article as 14th Amendment concerns.
Mhm.
Can you talk a little bit more about whether you think these arguments should be asserted separately? Should they be together? Can you help?
Right. So this is emphatically a speech claim. It's about a
Okay.
speech right, a right in each parent. It's not an equality claim. Too much of the litigation over public schools, and it's usually about shifting money amongst public schools, as if with this limited sphere of schools and just shift money around within them. Too much of that has been based on equality arguments, and obviously those have not been entirely successful. I want to get away from that. There's a liberty claim, not an equality claim. On the other hand, if you're concerned about equality, and I don't just mean some formal definition of it, but genuine equality, real opportunities for people who come from less wealthy families, one should embrace the liberty argument. And in that sense, the equal protection argument is really a moral justification for the liberty argument. The reality is Brown versus Board promised a sort of equality, but didn't really get equality for most kids. Maybe in some instances, some equality, but we still have schools that are grossly unequal, and that certainly correlates with wealth and to some degree with race, and that seems unjust. So anybody who takes at least the ideal of Brown versus Board seriously should embrace the freedom of speech argument. It's a way of, as argued in the paper, it's a way of carrying out the promise of Brown. That's not going to be carried out through disputes about funding amongst, resorting out funding across different district lines. So the equal protection argument is a moral reinforcement of the liberty argument, but it's ultimately a liberty argument, not an equality argument.
Okay, all right. That was clarifying to me. I appreciate that. I have one more question, I think, that I want to ask you, and then I want to turn it over to you to sum up all the things that I didn't mention. But this question I think is very telling in the world of journals. Did any journals decline to publish your article?
I don't even remember. I'm sure. I think one hesitated. Stanford hesitated. One or two others didn't answer, but Texas picked it up really quickly. So I wasn't able to test that, and I was delighted. Texas just said yes very quickly. I was happy with that, and so forth. But if your question is a lot of are articles from the Boyne point of view deprived of an opportunity for hearing law review articles? In law reviews, yes, the answer is definitely that's true. And it's not just me. Anyone writing from a conservative or libertarian angle, but especially from a conservative angle, cannot easily publish anymore in law reviews. And that's particularly true outside of law and economics. And it's especially true, of course, in areas like constitutional law. And in fact, there was a while when I stopped writing law review articles for about a decade because I simply couldn't get them published. Those that I did get published, I got through the kindness of colleagues at other schools who essentially forced it on law reviews. And just to give you a sense of it, I've been blacklisted at the Columbia Law School, my own home law school law review. And what they said is, we don't mind publishing you, but not those administrative arguments. Well, those were the arguments I was making for a decade or so, so I couldn't publish there. And they were quite explicit about it. And that blacklisting was still in place, at least as of about a year ago.
I wish.
It's not a big deal. I can publish elsewhere.
Right.
One of the reasons I've shifted to books is because it's less of a problem there. It is a problem there, but not to the same degree. So yeah, it is a problem, but that shouldn't get one down. One just publishes where one can and moves on. It's not there are worse things in life.
But it is something that most people don't think of.
But it's very real. That's right. You cannot judge an article by where it's published because some points of view are just not publishable in the better law reviews.
I see that very well. Thank you so much for answering these. I'm going to turn it over to you, Philip, to give
Okay.
us some comments that you have, and then we will have time for audience questions.
Okay. Well, I don't have any particular comments to make, except that I hope one day we'll all be liberated from the current system. Exactly how that will happen, don't know yet. But we're definitely thinking about litigation. And there are a lot of complicated questions in this sort of litigation because one has to persuade people socially and morally before they're just hit with the legal arguments. So there's a lot of spreading the word will be very important. But I do think at least some judges will be willing to go for this. We'll see. I'd love to hear the questions.
John,
Yeah, I've been monitoring the chat and I don't see anything there. That doesn't mean there aren't questions. Maybe the members of the audience just didn't want to write it into chat. So the multitude, please, please chime in with your questions here. And if you don't have any, well,
I welcome any advice as to what we should be doing here, because as I said, there are all sorts of things one misses writing something like this. And I'd love any thoughts or advice you can give me.
Hey, Professor Hamburger, this is Michael Bindis from the Institute for Justice. Great presentation, great article. I agree completely with you on the doctrinal points. I also share in your concerns about the reluctance of some judges who, to be willing to embrace the argument. But one question I had for you is, and I think this is the strongest point I've seen that could cut against you in making these claims in the court of law. And that is the rejection of Joshua Davies' free speech claim in Locke versus Davey, where, of course, he was denied the ability to use a scholarship to study devotional theology. He claimed that that was viewpoint discrimination, and the court rejected that claim by saying that a scholarship is not a forum for speech. And I wonder if you have any thoughts on that and arguments against that point.
Right. I forget exactly how old he was, but he was he was no longer a minor, right?
Correct.
And I think that puts it in a slightly different sort of box. Because what we're talking about here are not the rights of students. We're talking about, and that's very important because, of course, there's a lot of doctrine, very complicated doctrine on the rights of students in schools, which much of it's quite muddled. This is rather the rights of the parents. And if one starts with the assumption, I don't think unreasonable, that parents have a right to choose the speech with which they educate their children, then the system by which there is compulsory education for children underage, right? Compulsory grade school education and funding of it at across the board. I think it's very different than Locke versus Davey. Does that make sense?
It does. Certainly
further with the limits of the Blaine amendments, but that was my initial thought.
Sure. Yeah, no, I agree. Certainly the compulsion piece is not there because this was a higher ed scholarship program. But I guess the concern that I have is that the court kind of didn't reject the notion that education is speech, but it did say, point blank, that a scholarship is not a forum for speech, that the purpose of the scholarship was not to facilitate speech, which would seem to implicitly question the idea that education is speech. So.
Right.
I'm sorry, go ahead, Philip.
Right. If we were talking about the speech right of the student, I think that would be true. But we can imagine all sorts of education in which there is no speech right for students. That was certainly true in one of the schools I went to, where if you raised your hand, it was looked upon as some sort of aberration, a moral failing. It was just meant to listen and write it down. And but when we're talking about the parents' right, it seems to me that is entirely a matter of speech, and so it's very different from the forms of education that I don't know if a scholarship really, the court's right about that, but even if the court is right that scholarship's not a form, or at least that scholarship's not a form of speech, I don't think one could say that of education, the educational rights of the parents. But it's a good question. I'm going to make a note of that because I think that's something we have to distinguish.
Yeah, while Philip is making a note of that, let me jump in here briefly because Neil McCluskey did write a question in the chat, and I want to have that one be next because Neil needs to leave us a little bit early today. So when Philip is,
I'm ready.
oh, okay. Okay, so this is from Neil McCluskey. What would be a good legal strategy to advance the speech argument? Is the difficult part finding someone with standing to launch a suit?
No, I think everyone has all parents have standing. Standing, I don't think we have a problem. Finding clients won't be a problem. Finding the right clients, that's always a matter of which one wants to take great care. But as the Institute of Justice knows, but I don't think standing is the problem. I think the problem is anticipating the non-doctrinal concerns of judges and then addressing those before they actually decide the case. And, you know, we don't have a budget as IJ has for a massive a video campaign, but somehow one has to make sure the judge is not just blindsided by this and thinks, no, this is crazy. That's the real problem. And so we'll see. I think the doctrine standing, I hope those line up. But what is a problem, it's just these sort of inertia, attachment to the existing institutions. And that depends on variables that are more complicated. And I don't have any answer to that yet.
Well, I can tell you before we go to the next question that Martha and I will be looking for them.
Yes, we will.
Thank
Absolutely.
you. Awesome. Thank you.
Any more questions from the panel?
Colleen
From
has a
the
question.
viewers? I'm sorry, Philip, did you want to add something?
I think Colleen has a hand up.
Oh, okay. Colleen, unmute yourself and go for it.
Sure. So I don't know if I'm thinking right or not, but I worry that when Obamacare was okayed by the Supreme Court, I thought that was so crazy. And it feels like if they can make that be something that the government compel, that makes maybe the chance that they'll say they can't compel schooling. I just don't know how likely it is to get through, given that they would approve something like Obamacare, even with a supposedly conservative court.
Right. That's right. So the Supreme Court is not where I want to end up on this too soon. That's right. Many people think the goal of a civil rights organization is to get to the Supreme Court as fast as possible. That is not my desire ever. Occasionally, but usually not. They make so many unforced errors, and who needs that? Right. So one, I don't necessarily want to get to the Supreme Court soon. More than that, I don't know that Sebelius is really an obstacle. Sebelius, in part, for example, involved commandeering of the states. That's not an issue here because this is really about the states, not the federal government. So there are a different set of issues there. I think they felt tremendous political pressure to conform there. Here, I'm not sure. There'll be a lot of pressure on the other side from teachers' unions, but there'll also, I suspect, be a lot of pressure from parents. I think it'll be actually a more balanced thing. And it's not if it comes up in a state also, it's just going to center on that state. It won't be a national agenda yet. So I think we can, it will be difficult, and I worry about that, but I don't think it'll be on the scale of trying to fight Obamacare.
May I add to that really quickly, please? I know with Brown v. Board, it was a number of state-based lawsuits that were amalgamated, I believe, under the one name of case. So is that what you would anticipate is?
I don't like amalgamating the cases in a situation like this. I want as many rolls of the dice as possible. So it strikes me when, we can do this at the state level without the First Amendment. One could do this even with the First Amendment, but just state by state in separate cases. Maybe if one's lucky, one will get a division, even though, inevitably we'll lose some, but maybe you win a few others. You want those all separate.
Okay.
So not too many eggs in one basket, I would have thought.
Okay.
I'd like to jump in with a question. What are the risks going forward in changes in Supreme Court membership?
That's right. I don't know. I think the risks are lower now than the risks would have been a few months ago before the election.
Well, yeah.
Right, because which way does it, will it make any difference? I don't really know, but it's not as risky as it was. And again, I'm not necessarily in a hurry to get to the Supreme Court in any case. So, one's initial concern has to be who are the judges one meets at the state level or in a federal district court.
Okay. Yeah, my initial thought, and I'm glad I asked, and I'm glad you had that answer, is we have about 4 years to get this to the Supreme Court. But maybe some good conservative judges will be appointed in the last year of Trump in case we
I'm not
that admitted.
I'm not going to worry. I'm not going to worry. I'm not going to hold off for fear of the Supreme Court, and I'm not in a hurry to get the Supreme Court. I understand the reason for that. I think the Supreme Court probably would want this sort of thing to percolate for a while in any case, if we can manage to get one or two victories. So I don't think this is going to be, I don't think anybody would want to tee this up too soon at the Supreme Court.
I understand now. Colleen has raised her hand. Colleen, you have another question?
Yeah, sorry, one more. When you're talking about this would be more balanced with the political pressure and stuff, do you think that there is that kind of support among parents to get rid of compulsory education? I feel like it's still pretty popular, unfortunately.
That's right. So first of all, I would never say this about getting rid of public education. On the contrary.
Sorry, compulsory.
This is just about removing the pressure to push people into it. And by the way, that would give parents much more influence on their public schools. So one way of thinking about this is, if we think about how to explain this to people, it's not simply about allowing you to take money and go to a private school with it. It also, and I'm sorry I didn't put this into the article, but your question leads me to think about it. It's good. It gives enormous power to parents at public schools, and that's invaluable, because that's something one doesn't always have. If you're in a minority in a public school and you're on the outs, it's nice to have the ability to walk, because that's how you negotiate. So even if you want to stay, it gives you that sort of power. And by the way, at private school, this is a problem too. Some of our older kids are in a private school, and they don't, they want us to stay, but they're not going to twist themselves into a pretzel to get us to stay. And that's a pity. I want more power, and I think every parent does.
John Craig McCullough has a question. Do you want me to read it out? He wants to know what the potential unintended consequences of a lawsuit might be.
Well, one could lose. That's always a sad possibility. And given the risks, I think some losses have to be anticipated, which is again why one doesn't want to put all one's eggs in one basket. Right. So the real risk is losing, and you don't want too broad a precedent coming out of that.
Okay.
That's the main risk I see. Now, there are other risks down the road, right? Will parents of a terroristical frame of mind form a little school for little terrorists? That's a real problem. One can imagine, though, that could be addressed by general state legislation. I don't like the thought of this, but general state legislation. You don't need to, and actually federal legislation already in part deals with this, but one doesn't need to avoid the speech argument to deal with that, I think.
Okay.
Yeah, you can't teach breaking the law. Leslie, you have a question.
I do. And so my question is this. So in state to state, The state constitutions will all say that the legislature has a mandate by their state constitution to fund public schools. There is not language that says that parents are obligated to send their kids to those public schools. However, statutorily, that's where you find the offending language, I guess I should call it, that says that sending your child to a public school is the default. And if you want to do anything else, well, then that has to be something else. And of course, it's the something else category that those of us who are working on adopting school choice programs, that's where we play, is doing the something else. But it occurs to me in this discussion, though, that's really what this is. We're doing an add-on, this something else, rather than really attacking the source, which is the public school system. Even though there is a constitutional requirement to fund government schools, there does not have to be a default position for anybody to have to send their kids there. And it should be an option. And when you look back historically, well, there were a lot of reasons why those provisions were put into state constitutions. A lot of that was, bribery from Congress, so people could get statehood. There was a lot of that going on. But in the earlier days, though, it truly was that parents were educating their kids at home. But as the economy shifted from primarily agrarian to now something different, kids needed different kind of skills than information that the parents didn't necessarily have. Then having a public school became an option for people if that's what they needed. And, now, of course, everything's gone to hell since those days. But it occurs to me, if we give maybe, and I wonder what your thoughts are, if we give more thought to that statutory presumption language that you'll find everywhere, that because there has to be a funded system of government schools, there has to be also a default position for parents. Maybe that's a way to address this in a way that will open up the argument more. And I say this because so oftentimes when you start talking about these ideas, people may shut down pretty quickly. Well, but the Constitution says we have to do this. Okay.
Right.
It doesn't say as much as people think.
Right. I think that's very interesting. I like that. We are nothing in this proposal would impede states from meeting their constitutional obligation either to fund or to actually organize and run public schools. It's not an anti-public school
right
argument, but it does require the government not to use the funding to herd people into public schools without leaving them a real economic opportunity, real freedom to choose the other things should they want it.
Yeah,
that's right.
Yeah. And this really starts leading us. So I'm a Milton Friedman girl. And so, of course, Milton thought, that choice, the parent's choice is paramount and should be a wide open choice. Of course, now we're dealing with the funding question and that wide open choice. But ultimately, he saw us going to a point where, we would handle the funding piece and how we educate our kids on our own. I think that may not come in the lifetime of anybody who's on the Zoom right now. But nonetheless, if we could at least get past this presumption that public schools, that's it, and anything else is something different or extra, just that alone, I think, would be just hugely helpful. And framing it up in this way that you're suggesting, I think, just has some merit.
Thank you.
I've got a comment from Natalie POTUS of the Skillman Foundation. And basically, I'll read her question here in a minute, but basically, her concern is about developing a communication strategy to message this, to address some of the things, Philip, that you mentioned about these judges being overwhelmed with the responsibility to change something that's been around a long time. Let me read her question just in case I missed some nuance of her concern. This seems to be a challenging argument to message to a general public, explaining it in common sense and compelling ways. Are you thinking there would be a narrative comm strategy that accompanies the legal action?
That would be very nice. I don't know that we have the resources or funding for that. I don't know if we have the skills for that, which is one of the reasons why we're proceeding cautiously. If anyone has thoughts about that and how to get that done, I would love, including from you, Natalie. I'd love any suggestions. We have done some good messaging. My favorite was the deference stall, getting rid of Chevron deference. I don't have one here, I don't think, but it's a little, those dolls you push the bottom and it flips over. So it could do various forms of deference, bowing over, which was lots of fun. But for a more sophisticated communication strategy, that's something we have to work on. And really, any suggestions folks have how to get that done, I'd be grateful for.
Well, just thinking out loud and having met Natalie last month, I think we just found somebody that's been inspired to help on that account, because Natalie is a communications professional. So
Great.
yeah. So
please send me any suggestions, give me a call, whatever. I'd love to talk to you about it.
And Philip, I think we're at the point where you suggested you would like to sum up at 5 till and then be off to something else.
Okay. Well, first, I just want to say thank you to each and every one of you. This has been a great opportunity. I've already got some good suggestions about modifying the argument and about thinking more about communications, and that's wonderful. I really appreciate it. I've always thought there should be a journal of second thoughts where you can add to your article the arguments that one forgot got mentioned afterwards. So, but in my mind, I have these in litigation that will be very useful. So thank you very much. What can I say generally, except that I know it's a bit of a long shot, but that doesn't mean it's not worth trying. And we'll see. I think if we get enough help from people like all of you, it might actually work. But we do have to figure out how to persuade the judges, not merely in a legal argument and rationally, but in an emotional way, in a way so that it seems natural to them, something that is almost inevitable and they have to go along with. So that's my hope. But how we're going to do that, I don't right now. So thank you, everyone.
That's our challenge and moving forward. And as the head of the Institute for Objective Policy Assessment, I can certainly promise a forum for any first or second thoughts on this matter.
Thank you.
This is what did Churchill say? The end of the beginning or the beginning of the end or something like that. But this may be kind of the middle point of the beginning.
Yes. He also said, "Life is a struggle. Get out and struggle." And I think that's true.
I like that at least as much as my recollection of his point.
Any case, thank you ever so much. Thank you for your time and your thoughts. And
thank you very much, Philip.
This really is an important civil rights point, and I hope we win it. Thank you.
Yeah,
Thank you.
Thank you.
Yeah, we need to.
Thank you all for attending. Appreciate it very much.
Be in touch with me if anyone wants to.
Thank you.
Talking. Thank you.
It's very helpful.
Definitely do that.
Great. Take care. Have a good afternoon.
Thank you. It's been awesome.
Bye, everyone.